Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, law made simple. Here's your hosts, Sam and Gina Ventola.
Hey, podcast fans. This is the Sam the Answer Man podcast, and we are so glad you're here. I'm Gina.
And I'm Sam.
And Sam, I got a ton of stuff to talk to you about in the employment realm. Can we talk about non-competes? Are they enforceable? What are they?
So a non-compete agreement, sometimes we call them restrictive covenants, are agreements that are typically entered into between an employer and employee. And basically it's something the employer makes the employee sign when they start, and it says that, you know, when our employment arrangement terminates, whether I fire you or whether you quit, you are prohibited from working for my competitors or for some other class of business in a certain zone and for a certain amount of time. And there are a lot of different ways that they're written, but that essentially is what they involve, as well as perhaps a prohibition against taking on, if you do enter a competing business, taking on clients or customers of the employer's business, again, for a certain period of time. So there's something that if you sign, and a lot of times employees sign these without reading them and thinking about them, if you sign them and you end up getting fired or quitting for that employment, you have a problem with trying to compete. And they may apply both to if you have your own competing business, or if you're working for somebody else. They'll still prohibit you from taking that job if it's going to involve you competing against your former employer.
So are there any exceptions to?
Well, they're not exceptions. So the enforceability of covenants not to compete are a matter of state law and specifically state statute. So the enforceability of the covenant is going to depend on what state you are, but I can address Colorado. In Colorado, we have a state statute which says generally non-compete agreements, covenants not to compete, restrictive covenants, are not enforceable. However, the rule of non-enforceability has 4 exceptions that if the case falls, if the situation falls in one of those 4 exceptions, the covenant may still be enforceable. So one of these is if the covenant arises from a sale of a business. So if I sell you my business, and as part of that, you say, okay, you're not going to compete against me for a certain period of time or a certain zone, that can be enforceable because it's considered, if I got paid for my business, is probably part of what I'm getting paid for, and so they can be enforceable. However, in this and all of the other exceptions where the covenants are enforceable, they still have to be reasonable. So you can't say you can't compete against me anywhere or for how long or for any period of time. Normally you have to have a geographic area where the non-competition is, and you have to have a period of time when it expires. And what's going to be reasonable in terms of those geographic areas or periods of time is going to depend on the industry. You know, basically, how far do people typically go? If it's a doctor or something like that, it's going to be a fairly narrow thing. But if it's something that is fairly specialized and there are only a few people across the country who do them, you're going to have a wider geographic thing. And the facts, again, are going to depend on whether the time period is reasonable or not. That's all not an exact science. It's something that's going to have to come up if the covenant is not to compete is being enforced in those circumstances. A second exception to the rule of non-enforceability of covenants not to compete is says that if the covenant is for the protection of trade secrets. And it's not really clear what this means, but clearly a trade secret provision is going to be enforceable, and if later employment is going to involve breach of that trade secret obligation, then the covenant may be enforceable, at least to the extent needed to enforce the trade secret provision. The third one is if you've been trained by your employer at a significant cost to the employer, and they want to recoup training costs. If you leave that employment then the covenant not to compete, at least to the extent that it requires you to repay those training costs, may be enforceable if reasonable. And then finally, there is one that says that covenants not to compete may be enforced if reasonable if they involve managerial or supervisory personnel, executive or management personnel, or the professional staff of executive or management personnel. And it's not clear what that means, but it essentially means you have to be somebody who is very high up in the company and involved in supervising a lot of people. If you are that kind of high-level employee, a covenant not to compete that you were signed may be enforceable, again, if it's reasonable.
So what about agreements? So I get that you can't take clients with you. I mean, you see this a lot with like hair salons,
right,
for example.
Right.
But what about coworkers? Like, I'm going to go start my own salon, and I want you, and you to come with me.
Yeah, that's a good question. So the statute that I just talked about, which makes covenants not to compete generally unenforceable, does not apply to contracts not to hire employees away from the employer. Those are generally enforceable, and they do not have to satisfy the 4 exceptions that I just talked about. So if you had if you've made a promise not to hire the employees of your former employer, that is generally going to be considered enforceable. It's not the same as a covenant not to compete. So clients and customers are analyzed according to covenants not to compete, but promises not to hire employees are different, and they are generally enforceable.
So going back to the hair salon thing for a moment, what if your stylist, my stylist, is leaving the salon, but I was their client before they came to that salon?
Right. Well, if they have signed a covenant not to compete, it's always going to depend upon the language of the document. So first of all, you have to look at what the document says. And sometimes they just say you can't solicit our employees, but sometimes they say you can't solicit our customers, but sometimes they'll say you can't work for them at all. And if they say that, then according to the document, it may be enforceable. There may or may not be an exception for clients that you previously had when you went in. But the way these things are generally drafted, that won't be an exception. It'll say anybody who we served, while you were here is considered our customer. And so if that's a concern of yours as a stylist going in, that, hey, I have my own customers, and if I leave here, I want to be able to, you got to make sure that you have that provided for in the covenant, in the document, that you make that exception. But again, even if the document says that you can't take on that customer after you leave, that document may or may not be enforceable depending on the 4 exceptions and the criteria of reasonableness that we talked about earlier. That's probably a more complicated answer than you wanted to that question. And unfortunately, it's sort of a complicated area in the law, and it is one which, it makes sense for people to look at before. I mean, sometimes I have clients who say, I have this issue where I'm being accused of a covenant not to compete. And, really, I would recommend to anybody who is contemplating leaving employment to, at that point, when you first start thinking, I'm thinking about making a move, to consult with an attorney, because not only are there possible issues with covenants not to compete, but there are also issues, and I don't want to get into another topic too far in this podcast, but there are issues that happen when somebody is leaving an employment and they're like starting their own business. Well, that could be, some of those actions can be considered to be in violation of your fiduciary duty to your current employer if you're doing them while you're still employed. And you really want to be on guard about those issues, as well as covenant not to compete issues, before you leave, before you start making mistakes and then having to go back and say, oh, what are my legal rights based upon what I've already done.
So if business owners need an enforceable non-compete agreement, what should they do?
Well, again, that also on that side, they should talk to an attorney to try to come up with the circumstances where the covenant not to compete would be enforceable in the circumstances that it wouldn't. And to know going in, even if you have this agreement, it's not going to be enforceable, or to craft the agreement in such a way as to make it most likely to be enforceable. And on the issue of reasonableness, you know, if you can curtail it to something that is reasonable, you can make it enforceable when it otherwise might not have been if you had been unreasonable in either the length of time or the geographic area that you specified. So it's a good idea to talk about these issues with an attorney in considering what covenant not to compete you're going to ask your employees to sign, as well as any other employment issues. We just recently did a podcast on issues of employment at will agreements, agreements with employees. Really, you should speak with an attorney about what you think you might want to ask your employees to sign, and whether it's going to be enforceable, whether it's going to be reasonable.
So, in a nutshell, business owners, if you need help setting up your employment agreements, non-compete clauses, everything, talk to Sam. You can reach him at sam@samventola.com. You can reach out to us, and in fact, you can go on our website, ventolalaw.com, and right there on the main page, you can schedule an appointment with Sam. Online. It's wonderful. Versus having to call. Don't you hate having to call and wait on hold and look at your schedule and look at their schedule and see what works? I know I do. And so we came up with this online scheduling so that it gives you your time back. So we want to reduce your stress. We want to reduce your frustration. There you go. So if you want to talk to Sam, schedule your phone consultation. Just go on our website at ventolalaw.com. Podcast fans, we have not left you out. You can find us. You can click on subscribe right down here at the bottom if you're watching us on YouTube. You can also, audio podcast fans, find us on iTunes, where you can subscribe to us there. We're also on Twitter, on Instagram, and on Facebook. So if you can't find us, let me know, and I will point the way. So thanks for listening. Thanks for watching. Sam, do you have anything else to add?
Nope, that's it. Thank you for coming.
Awesome. Thank you.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.
Hey, podcast fans, we are so excited to share with you our new hashtag promotion. Since Sam is so passionate about the First Amendment, we're launching hashtag Faces of the First Amendment. We want to see you exercising your First Amendment freedoms. So in the coming weeks, we're going to be posting a series of photos that have people like you, like me, like Sam, even maybe one of our daughters or two of our daughters, exercising their First Amendment freedoms. So Sam, could you give them some examples of photos that we're talking about?
Yeah, so a lot of people think the First Amendment only protects what you say or maybe what you write. They don't realize that our First Amendment rights are expressed every day in a lot of the things that we do. If we're an artist, it's expressed in our art, whether we do it professionally or privately. That's protected by the First Amendment. The information we receive, the music we listen to, the demonstrations we may be in, a lot of things that we do throughout our day or our careers are protected by the First Amendment. And what we'd like to do is show you some pictures that we've already collected of people expressing their First Amendment rights, and have you send back to the same hashtag your pictures of yourself or others you may see expressing First Amendment rights.
So be on the lookout for more details about our new hashtag, Faces of the First Amendment, and celebrate your rights guaranteed under the First Amendment. Thanks, guys.
Thank you.